Matt Day here with Parsons, Graham and Day. Want to take a second to talk about continuing exclusive jurisdiction. In Oklahoma, for custody proceedings, the UCCJEA would require that a court that made an original determination of custody and visitation and a modification action is sought, determine whether or not it has continuing exclusive jurisdiction over the matter. Now, in most instances, it's going to have continuing exclusive jurisdiction because the parties, the child, people acting as parents who have custody of the child are still residing in the state. So most cases that's fairly simple because people get divorced and they just stay in the state in which they got divorced, for instance, Oklahoma. Sometimes what you have though is a situation in which the parties get a divorce in one state and then move to another state, and then the question becomes, is there jurisdiction, right? Where is jurisdiction going to be appropriate? So first of all, a determination of whether or not there's continuing exclusive jurisdiction would come from the court that made the original decision. That court decides whether or not it has continuing exclusive jurisdiction over the parties. Continuing exclusive jurisdiction is lost, however, if the child and a parent, the child and a person acting as parent move from the state and substantial evidence of the child's well-being or care is located elsewhere. All right, so we got divorced in Hawaii, and then the custodial parent and child moved to Oklahoma, and now the child's been going to school here for several years, their doctor is here, so on and so forth, right? Hawaii probably lost continuing exclusive jurisdiction. Another way that can happen is if everybody leaves. The child, the parents, and persons acting as parents leave the state, and then exclusive continuing jurisdiction can be lost that way. When we're filing for a modification, we want to make sure that we file it in the appropriate place. If your decree is from Oklahoma, there's a good chance that Oklahoma is the appropriate place. However, it may not be anymore. Similarly, if it's coming in from another state, we may need to take other actions to register it because another state may have had original jurisdiction and would need to give up that jurisdiction in order for Oklahoma to make any sort of modification of the existing order. All right, so continuing exclusive jurisdiction is necessary for a court in Oklahoma to make modifications of visitation and custody orders, and it is a determination of the court that made those original orders, right, to determine whether or not it has continuing exclusive jurisdiction. If you find yourself in a situation in which you're not sure where to proceed, where the modification should be filed, or if you find yourself in a custody or divorce situation, call our office today, and we would be happy to walk through the facts and the law with you so that you have a good understanding of what your situation is. Our number is 918-307-1529.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham, and Day and anyone watching this video.